my dear friends. This is your host Jyotsna Sharma welcoming you to Mana TV and Mana TV International. This is Voice of Legal Immigrants. And the current trends are changing with regard to immigration in the United States of America. People are confused with the new executive order that President Trump has signed. But you should not be worried because we are going to give a solution and the right information to that EO as well. Today, we have a very special guest with us, a person who has fought for the rights of the H-1B community, who has been very successful in winning cases. I mean, in the litigation that he did against the USCIS in the previous years, he has always been successful in getting the right decision for the H-1B people who lost their H-1B approvals or whose approvals were denied, or whatever problems were there, he was always there to solve them. Today, he is with us. His name is Attorney Jonathan Watson, and he is the partner in Wasden Baines LLC, a very reputed and a very committed person towards the legal immigrants in the country. So I would welcome him today, and we will talk about a lot of good things that are related to the rights that H-1B can have and can fight for themselves and don't get into the misery of H-1 denials anymore. Jonathan, welcome to our show.
Thank you. It's good to be with you.
Thank you so much. I know it's virtual, and that's the trend these days, working from home studios with this coronavirus situation, and the world has come to a halt. And that's where I believe things are changing. And that's where the executive order also came into place by President Trump.
Yeah, the executive order was strange, to say the least. It doesn't apply to non-immigrant visas like an H visa. It only applies to a limited, very, very small category of visas, which if you're coming from out of the United States, if you're not presently in the United States, and you have an approved I-140, then they will not issue you a visa at the consulate for this time while they're on pause. It doesn't apply to family-based green cards. It doesn't apply to green cards being issued for those people already present in the United States. And it doesn't apply to non-immigrants coming into the country. Cynically, I would say that it doesn't apply to non-immigrants because President Trump's hotels rely heavily on the H-2 visa. And so he wouldn't want to damage his industry and his financial interests by excluding H visas from the mix. And it would be hard to justify intellectually why H-2s would be allowed in and not H-1s. So non-immigrants are exempt from the ban, and it only applies to people receiving the actual physical green card overseas and entering into the United States.
Perfect. I have a lot of questions related to that. And in fact, when we were putting the title of this show, while all the other people, different forums and different channels are showcasing President Trump's executive order, discussion on immigration and that topic, I felt we should not do it because somewhere, I knew it's really not going to bother the H-1B community. And of course, with a conversation that I had with you previously. So that's the reason we should not try to create panic. And that's the reason I did not put that as the main tagline for our today's show. So John, today, first of all, I would like to take a good introduction from you about yourself, because you have done so many good things and I could not summarize them, or I could not remember them right now, teleprompter not being there in front of me. I would like you to please give a brief description about the cases that you have handled previously and your introduction of your organization as is.
Sure. So I'm one of the partners in Wasden Baines. We are a law firm headquartered in South Carolina, and we have a DC office. And our entire focus of our firm is challenging the US government's immigration decisions and policies in federal court. So it's very much a small niche area. We don't really file a whole lot of petitions for people. We try to focus predominantly and almost exclusively on litigation. We, when you sue the government, there's one office that tends to defend the government within the Department of Justice. It's called the Office of Immigration Litigation. All three of the attorneys in the firm, there's three of us, worked in that office.
Great.
We have myself. Down the hall from me was Jeff Forney, who is the senior litigation counsel. He's with us. And Brad Bannis was also with us. So we got our training from the government. We left the government and we went into private practice. And now we're litigating against the people that we used to work down the hall from.
Well, what a contrast. And John, I tell you, I am having continuous calls coming in. I will pick this call to understand. Okay, this went away. So there are a lot of callers already there who have called me multiple times to talk to you and ask questions. Well, the first thing first, the litigation. I mean, you recently won a case, against USCIS about this establishing the employer-employee relationship where H-1B denials happen. So before this winning of this case, what was the ground where you started this litigation? What all happened? Want to know a little bit.
Yeah. So it's no secret that the agency does not like the IT consulting, IT staffing industry. And they've come up ever since 2010, they've come up with more and more rules that penalize this industry. So in 2018, they kind of upped their game a little bit and they came out with a new policy memo that did a couple of things. One is it said you have to have actual control, which the employer who signs the LCA in order to have an employee-employee relationship has to manage the day-to-day work of the employee, and the employee's work has to be directly related to that employer's business. They also said that if you're placing somebody at third-party locations, you have to provide evidence of guaranteed work assignments, specific work assignments for 3 years. And if you don't have this day-to-day itinerary of what you're doing for 3 years, they would either deny it in full or they would deny it in part. And so we started seeing a massive increase in these short-term approvals or partial denials of the H-1B visa, where people's visa was getting approved for 1 day, a week, a month, sometimes a year. But anybody in the IT consulting industry was seeing approvals that were very, very short. And when they did this, they weren't explaining why. They were just giving you an approval notice and you'd have to understand why you were only approved for a day. So that was obviously causing a lot of problems because it creates an impossible standard. No employer in the world can guarantee what their employee is going to be doing for the next 3 years. And the rules that they came out with contradicted regulations and contradicted the statute that Congress passed. There was another statute Congress passed called the Administrative Procedure Act that says if you're going to deny a visa in part or in whole, you have to give a written explanation as to why you're doing it. So when they were denying part of the visa and shortening the approval period, they weren't explaining why, and that was a very clear cut, in our opinion, violation of the law. And so those are the three things that we really attacked in the IT USERP case.
Thank you for the inputs on that, John. Very interesting. And in fact, just like, yes, millions of lives. I mean, a lot of hundreds and thousands of people their careers are at stake because of that. Right now, I have a caller and I will take this caller right now. Hello.
Any plan available, or what are the options that we can, approach the USCIS to waive the biometric steps?
Okay, thank you for your question. And I will, reiterate the question. John, were you able to hear the question or should I reiterate for you?
Can you reiterate it for me?
Okay, so basically, he recently filed for the H-4EAD for his wife. And what had happened is, of course, this June 4, the USCIS is closed till June 4th. Now, the biometrics would not happen. And in this situation, of course, it's a generic question as well. Thousands of people on H-4EAD. Now, their fate is lingering. They were working somewhere. There's a gap is coming. Biometrics are not happening. So is there any way out while USCIS is taking its own time. They're asking about
Yeah.
that.
So it's curious because in other categories for EADs, they've waived the biometric requirement, except for H4s, which it's curious because the agency has said that they intend to try and revoke the H4 visa EAD access.
Mhm.
All of the things that we've been seeing in the H4 world seem to indicate the agency is deliberately causing problems for the H4 EAD so that they can
Right.
kill the program before they actually officially kill it. So what we've done just recently, because this issue is applying to a lot of people, so we've filed lawsuits challenging how long the agency's taken.
Mhm.
And for those that haven't had biometrics yet, we're going to have to include and incorporate some new legal arguments as to why it is unreasonable for the agency not to waive the biometric requirement currently.
Very nice. So this case is under process. I mean, you filed.
Yeah.
Any
Yeah, we filed
expected
about
timeline?
3 weeks ago. We filed 3 weeks ago. We'll probably start briefing the case within the next 3 to 4 weeks.
Perfect. Thank you so much. And John, I have another caller right now, so I'll take this call as well. Hello. Hi, Arun. Please ask your question.
This is good, but I just found the number.
Okay. So John, his question is about what will happen when the 240 days extension period is over. I mean, as it is as mentioned, and now that this travel ban is there and everything is there. Apparently, I want a clarification from you about the 240 days as well, because is it really 240 days extension that applies to everyone by default, or what are the procedure for that as well? I mean, all the question, all the more so please proper answer on that.
So if you have a valid H-1B visa and you file for an extension, the agency gives you 240 days if they haven't made a decision yet. And then as soon as they make a decision, then you're good. If you're coming up, the trouble with that is a lot of times they take longer than 240 days.
Right.
Then you run out of status. Or if they take a very long time, you end up getting, if you get a denial, you get a denial at the end of that and you have to leave the country immediately because your visa was denied and you're out of status basically the second you get that letter. So if you're on an H-1B, you really should be looking to challenge the agency in court on how long they're taking to make a decision on your visa, because the law says it should be in 30 days and they're taking up to a year at times. So you should be keeping an eye on that and start challenging the agency in court after it's been pending for 2 to 3 months, I would say, because otherwise you could find yourself harmed by the agency's delay.
Wow. Okay. Yes, definitely. I mean, people are looking for different options after that. That should they shift to B1 or B2 visa, whatever it is, or any other visa to protect themselves. But in the first place, yes, I mean, as you said, 240 days is enough a time. The decision should come. If it isn't coming, yes, I mean, from your expert advice, that's where.
And the other thing is they try to basically extort premium processing out of people in those situations because you're coming up at the end, so you pay premium processing, right? That premium processing fee is something that the agency uses to hire their FD&S, their fraud investigators, the people that go out and harass the H-1B workforce. So I'm always confused why people would pay premium processing to pay their own torturers, basically, is the people that are causing them the most grief are getting paid out of those funds. So it's the way we've structured our lawsuits. A lot of times it ends up being cheaper than premium processing to file a lawsuit against the government. So it's probably a better way to use your money than giving it to the agency.
Thank you, John. But then, you know what? Thanks for the answer. But there is so much of fear, I mean, there are so many things attached. Now, people run behind premium processing for the reason they know They're not
Yeah.
going to get an approval in normal time. People have taken 1 year, more than 1 year also. There have been
Mhm.
some cases, right? And as you say, 240 days, you yourself, like, you have people, right, filing litigation there as well. So this fear and to retain a job, and then of course their spouses, if they're on H4 EAD, their future also lingers, gets
Yeah.
attached to it, and they are also somewhere in the dilemma what to do. And that's the reason probably most of the people go for premium processing. That's where it is. So
So
I
that,
hope your answer is clear right now.
Mhm.
Thank you so much. Okay. Okay, you're right. Okay. Oh, by the way, it's a L1 case, John, not H1.
Oh,
So
okay.
for
Same,
a
same
change,
rules apply.
yeah, same thing applies though. Thank you. So John, very interesting thing, about uh, filing a case or going into litigation. I have a question from a public's perspective, individuals perspective, I'll say, rather, people who are on these non-immigrant visas. I mean, lately the lawsuit that you filed went through a group of companies, right? You represented them, right? And that's how it was filed. For a normal person who's a loner, a lone person who wants to file, they somehow feel, scared to file the lawsuit, thinking that maybe their name will come into files, and for the green card process, when it happens, it might jeopardize their, circumstances there to, get clear,
Yeah. We get that question quite a lot,
Mhm.
actually. So like I said, we have 3 attorneys in our office. All 3 of us have worked for the government and in the immigration field. In our experience across the board, when we were in government, was universally the same. People who sued the government and showed a willingness to go to court tended to get better treatment from the agency. So I used to get, when I went to USCIS to work after working in the Justice Department, I would sometimes review potential litigation cases. And the only thing that made them a potential litigation case was that the company had previously sued the agency. And there was a corporate memory that, oh my gosh, they've sued us. Let's not deny this, because if we deny it, then it goes into litigation and that takes all this extra time and work. So the pre-litigation or the potential litigation cases got treated far more favorable than
Mhm.
a regular case. So I would say, will it impact you? Possibly, but it wouldn't be in a negative way.
Okay, thank you. These words are reassuring for people. Now the thing is, you spoke of a company filing this lawsuit then. Can a solo person who holds an H1 file a lawsuit for himself or herself?
Yes, but it creates an extra legal battle that we have to fight. When the company sues the agency, there's no question that they have what's called jurisdiction or standing to sue. When the individual files the lawsuit, the legal rules are a little less clear. They're not so black and white. So the government will usually try to delay the case by filing a motion saying this is the wrong plaintiff. And before you even get to the question of whether or not the agency was wrong or right on the visa, you have this additional legal battle to fight, which honestly makes it more expensive. And so it's not the preferred way to do it.
Perfect. Thank you so much. I mean, that adds value. And of course, H1B is taken care of by the employer. So that's employer's duty to take care of them accordingly. I mean, secondly, H1B holders, H1B visa holders, their company will file a lawsuit in case if that happens. But for H4, people who are aspiring for H4 EAD, what's the take there?
So when you have a whole bunch of people with the same legal issue, the same legal problem, facing the same defendant, in this case, the defendant would be USCIS. When all of those people have a common legal question, they can be co-plaintiffs, and you can bundle them together in one case. And that's what we've been doing to challenge USCIS's processing times on H4s.
All right.
So we'll have up to 70 plaintiffs at a time in a case, and what we see is processing times for the H-4 and the EAD went from less than 3 months to up to 12 months if you're in California and Texas, I think.
Wow.
So that's their average processing time is 9.5 to 12 months if you're in California.
My
So
goodness, it's a long time.
it's clearly not very reasonable. So what we're trying to do is challenge the reasonableness of the agency's average processing time, because in a perfect world, the earliest you could ever file your H-4 extension would be 6 months if the H-1's employer filed the extension petition exactly at
Right.
the earliest possible moment. So if the earliest possible moment is 6 months, it's completely unreasonable to make somebody lose status for an additional 6 months while they wait and come up with an answer to the question.
Thank you. Thank you for the answer. And we'll go back to your, case again, where, so the situation that you mentioned was, of course, establishing all the relationship about employee, and the short-term extensions that they were getting. So post the litigation about the result, what did you do exactly, and how the result came, and what is the result? Let's share some insight on that, actually.
Sure. So their employer-employee rule, there's a regulation, and the regulation defines who a United States employer is for an H-1B. And it says you're a United States employer if you have the ability to hire, pay, fire, or otherwise control. So the plain language of the regulation says one of those 4 things and you're good. That's all you have to do, is show that you can hire, pay, fire. And if you can do one of those, you are the United States employer. What the agency basically did is interpreted the or as an and. They said you have to hire, pay, fire, and have actual continuous control over that employee's day-to-day operations, which is a total contradiction of the regulation. And the court agreed with us on that and said, no, what you've done is you've basically changed your regulation unlawfully by creating a standard that contradicts the plain language. So if you've got one of those decisions that's based on employer-employee relationship, you have a very high chance now of getting that overturned in court. Unfortunately, the agency is not going back, and they're not reopening on their own initiative and approving these things. They're making you go to court. Just Wednesday, we filed a case with 30 or so. Those will probably settle out, and those will end up most likely getting approved within 2 months. The other thing, the specific work rule was also tossed out because they were saying you have to have this continuous work assignment, evidence of continuous work assignments for 3 years. But the statute itself says if you're an employer, you can put somebody in a non-productive status as long as you continue to pay them. And the court said the agency's requirement contradicted the statute and was unlawful, and they couldn't enforce that. Now, these short-term approvals that we were seeing, these partial denials, were all premised on the employer-employee rule and the specific work assignment rule. So in theory, they were only approving the visa for the duration of time that you had these guaranteed work assignments for. But the court said, not only are those rules illegal, but the law requires you to go through and give a written explanation for why you're denying part of the visa, and you're not doing that. So those people that have had these short-term approvals within the last 2.5 years, if they're coming up and having to make a decision on whether or not to file an extension petition or filing a lawsuit to extend their previously approved petition, they can do either one of those. Now, as we've seen, adjudication trends in the agency are kind of crazy lately. The RFEs are crazy. The predictability of whether or not the agency is going to find you or in a specialty occupation, it's very uncertain times right now, and the denial rate is quite high. So I think it may well be safer for people in that situation with a short approval to take those cases to court and get the originally requested period extended,
Mhm.
as opposed to rolling the dice and subjecting yourself to the USCIS adjudication process right now.
For the dates, we got the extension. For how long? The past record of those approvals that were there with us, people who got approved in, say, last year, supposedly, and they wanted to apply for extension of 3 years, but got it for only 1 year. Can they revisit as well and file?
Yeah, I think realistically, anybody who has a case within the last 2 years is a good plaintiff for those cases. So,
Oh, 2
you
years.
could get your case extended for, up until that originally requested period. And I think it would be safer than running through adjudications again.
Okay, I have one more question, little tricky. One is people apply for their extensions. Second is people apply for an amendment. And
Mhm.
applying for an amendment, when they change a location of the job, it's also like a new H-1B extension only or something like that.
Yeah.
Now, supposedly somebody got an extension for 3 years, extension, but when the person applied for the amendment and he got another project, that extension was shortened. What is your take on that?
There's no predictability in the system right now. People
Right.
ask me to predict what the agency's thinking all the time, and it's impossible. There's no rhyme or reason to what they're doing. I've seen this happen several times. You have identical petitions, the exact same job, the exact same qualifications for the beneficiaries. One of the cases we have in court right now is like this. They made 11 petitions, 3 were approved, 8 were denied. And there's no explanation as to why those 3 were approved, because all the beneficiaries had a master's in computer science. All of them were for the same job and occupational code. So I can't predict anything they're going to do because I don't think they know what they're doing.
So tell me one thing, John. I mean, litigation cannot be the forever solution. Why is USCIS not taking the right steps to set a standard and solve this problem? I mean, litigation helps big time.
Yeah.
Because as you said, once that happens, you cited an example saying that, okay, some company files it and then they are in the books with the USCIS office. And then they know, okay, we don't want to get into trouble, approve their cases and whatever, right?
Mm-hmm.
Why so? Why is not there a uniform stance by USCIS when litigations are coming in the similar nature? Then in that case, they should have some uniform solution.
They should, but if you keep in mind the volume of petitions that they're dealing with in a given year, the number of cases that actually go to court is very, very small. Of their denials, probably less than 0.01 denials go to court. So until that volume increases, they probably won't make systemic changes. Now, the IT-Serve case was a little different because we challenged the nationwide policy and we challenged individual denials. But for the most part, like when you see these specialty occupation denials where they're saying a degree isn't required for your job, they're losing those cases all over the country right now. And it seems like every week you hear them losing another one. They're probably not going to change what they're doing, but I have seen that the cases that we filed have settled out with the agency much quicker because the agency realizes that they will lose those in court. So they're kind of changing course when they get sued. But so few people sue, it's not going to really force them to make a new policy or change the way they're doing things.
Thank you for the answer. John, I have another question. Now, you know that there is a very, very large segment of the community who is H-1B and, they have I-140 approved. I mean, they're waiting for their green card and green card numbers are not available. They're in a huge, green card backlog almost that ranges from anywhere between 20 years to 100 years of wait time. Now, these people are here trying to maintain their visas and everything, and no solution is coming through any bills that come to the Congress or Senate or any other executive actions, nothing has happened. They have been paying taxes in this country. They have been approved by Department of Department of Labor, saying that, okay, they are not occupying any American's job, right? And they are approved to get their green cards as well. So far, the visa numbers are available, they'll get it. This segment, this whole community is definitely looking for a solution from every angle, and be it a litigation as well. Is there a solution somewhere you suggest that this community can look up to? I mean, there are 500 or 600,000 such people in the backlog who are looking for a solution. Now, I will cite one example as well. There are more than 300,000 unused visa numbers, green card numbers available, which have not been consumed, and they have never been given to anyone. If it was the wish of the president of the country, an executive action might have helped, and it could be reallocated, those visa numbers. Or I don't know if there is any bill that can come and can help in that direction. So I need your inputs from a legal perspective. What could be the solution for them?
I think the solution to that problem is going to have to be a change of the statute by Congress. The way that the law currently reads, and I don't think there's really a lawsuit that can fix this, is that there is a numerical cap on each of these visa categories. And without something from Congress, that's probably going to be that way for until the end of time. Now, there have been moves within Congress. Certain bills have been recently proposed to alleviate that problem. The issue is you have the IT industry who has this massive backlog of their employees.
Right.
And then you have the nurses, the foreign nurse categories, or not category, but the foreign nurse employers who are accustomed to getting green cards for their employees almost immediately. And because there's a nursing shortage and nurses are, very sympathetic, especially right now, there's kind of a tension within the immigration community between the nurses and the IT world, because they both want green cards. And if that numerical limit is changed in any way, nurses won't be getting green cards because the backlog of the folks coming from India would take all of the green cards for 2 to 3 years. So I think that's part of the problem. And that lobby in Congress is very persuasive, the nurse lobby. So that's part of the problem that we're seeing with a statutory change, is that there's two different sides of the immigration world wanting a solution, and the nurses, I think, are probably right now at least winning.
I mean, there is no ray of hope. This means for time being for the H-1B community. I mean, people in green card backlog. I will not just quote it as a H-1B community. And these people are here for last 10, 15 years, So they are I-140 approved. They are in the green card wait line. They are approved for the green card. So, I mean, it's just not the H-1B category, if I speak of. Yeah. And they have to each year get extension year after year. And then, as you said, 2 months or 3 months or 8 months of extension. That's where it's happening right now.
Well, the agency has no incentive to change what's going on right now, because the dirty little secret is a very large majority of the agency's revenue that they use to operate, pay salaries, pay for buildings, do everything that they do comes from the H-1B program. So the more people that are in H-1B getting extensions for 20, 30 years in the future, the more money they make. So if they were inclined to use some policy changes to alleviate the problem, they wouldn't, because it's not in their financial self-interest. And I think that's the dirty little secret. They run on fees. No, it's not fair. Nothing that they've been doing lately is fair. But that's the dirty little secret, is they run on fees and they like their fees. And the Department of Homeland Security takes the fees that they have left over that they haven't expended on their operations and uses it for other things. So I think there's a vested interest in maintaining the status quo.
I believe, if these people were in the wait line for green card, if they were given approvals for their green cards, I believe they will invest more in the country. Uh,
Yes,
USCIS is one body, but the whole nation will tend to gain. There are billions of dollars that would come into investment in this country because there are a lot of people. There is more than $100 billion of remittance that goes to India because people
yeah.
are not sure that they will get to stay here for good. Would they be able to get permanent residency? They don't know. More than $100 billion in the last year or 2 years, has been sent to India in remittances. That money could have stayed here if that solution comes in. So I think as far as the concern for the USCIS fees and all the businesses that runs there, I believe the nation will tend to get better benefit if all these green cards are given to the people in the backlog, and they're the people who will be creating jobs as well. There is a prospect of getting businesses open. Entrepreneurs are there. A lot of brains here, as you know, this community, there, different fields, whether it's medical or research or IT field they are in, they're great. Anyways, thank you for those inputs. And my another question also relates to it with the current executive order passed by President Trump. He signed it, and then 60 days of immigration ban has come. And of course, you in the opening lines only you spoke about that it doesn't really hurt the non-immigrant community as of now. But one thing from a perspective of this visa numbers being not, it's not going anywhere. Almost 60,000 visa numbers for the green card, which were different kind of categories were there, because of the ban, they will be available. Do you see a prospect where the, this green card backlogged H1B or employment based rather category, I would say, not H1B, this employment based category, can they get these visa numbers if they don't get allocated to the family or other base?
So if at the end of the fiscal year, so the fiscal year ends on September 30th, as they approach the fiscal year's end, they tried to come up with a calculation of how many visas will not be used in that fiscal year. And then the employment-based visas, they will reallocate to folks that are in those categories that are oversubscribed. Now, they do the same thing for the family-based, but I don't think those fields cross. So it's easier for them to move around within the employment base, but not so easy to take a family-based visa that's not used and move it over to the employment-based.
There's no way out to get it done. I mean, these are visa numbers available. And maybe that's the reason those 300,000 visas, unused visas are lying because of that reason as well.
Could be.
Any executive order by the president, can it help?
I'd have to go back and take a look at the statute governing that to make sure, but I'm inclined to say probably not. A lot of those things with visa allocations are very statutory. And if it's in the statute, there's not a lot of leeway or wiggle room for the agency or the executive branch to change things.
Okay, thank you for your inputs, John, because, these are the things people are trying to find some hope there. And at the same time, they have to save their visas. Now,
Yeah.
question relates to the H1Bs and the extensions and the amendments and approvals and everything. Till June 4th, the USCIS offices are closed. Now there are people getting laid off from their jobs. A lot of contracts are ending because clients are, trying to be cautious and they don't want to spend money. There are a lot of projects that have closed, and people who are on these non-immigrant visas have been, taken out from they have been laid off, basically. They have been taken out from the projects. Mass layoffs are happening in this category of H1Bs as well right now. To their protection or to maintain their visa status or everything, what is your suggestion? Time being, should they look for parallel option of getting another visa, to stay in the country, or because they cannot go back? Travel ban is there. If they're from India, they cannot go back to the country. How do they secure and they stay legal here, law abiding, rather than breaking any norms and rules?
Yeah, so they have 30 days to stay in the country and wrap things up, and then before they return home. After 30 days, they go into an unlawful status. And if you're in unlawful status for 180 days, then you accrue unlawful presence. Unlawful presence, if you accrue any unlawful presence, there's bars that keep you from ever getting immigration visas again, or at least for 3 to 5 years. So that 180-day clock is something they need to be very careful about and keep an eye on. In terms of switching over to visas, different visa categories, I'd say that's tends to be very dangerous, because when you start going through the change of status process with the agency, I've seen them approve H-1B visas, but then deny change of status because they said you failed to maintain your previous status, your other visa category status. So I would say be very careful with that, and they probably ought to consult with an attorney on those individual specifics before doing anything.
What kind of litigation help comes in that picture?
What can, if they have an extension petition in, if their employer is willing to put an extension petition in for them, they can, and especially after the IT serve decision, they don't have to provide evidence of a work assignment. They don't have to provide contracts and itineraries any longer. So they should be able to get their visa through, and as long as the employer signs the LCA and abides by the terms of the LCA, they should be fine. And then when there's a new project that comes up, they'll just be assigned to the project.
Okay, thank you for those inputs. So basically, the case that IT Serve Alliance won was regarding, all the parameters we spoke about: employer-employee relationship, place of work, and the duration of the project and everything. We don't have to establish that. And citing that example of IT Serve's result, the result that came, or the ruling that came, people can file their own, the companies can file the litigation for their employee and get a further extension, right?
Yeah, they should be able to. Because if the agency were to deny the petition based on lack of work assignments, that would be something that would be pretty likely to lose in court for the agency. Something that we would have a high percentage chance of beating in court. So we can't give guarantees in law, but I would say the odds would definitely be in our favor on those types of cases.
All right. Thank you. If people have to take action on reviving their original time of extension that they applied on H1, because there have been cases people filed for 3 months, or people filed for 3 years, they got it for 3 months. There have been cases, the extension came after the extension duration that was approved was over.
Yeah.
Can they also revisit now and file a case?
Yeah, we're filing cases like that probably every week and a half or so, with a whole bunch of plaintiffs in the lawsuit. So the last one we did, I think we had 30 or 40 people who are suing to extend their visa petitions. Now, when you file a lawsuit against the government, ordinarily the government has 60 days to decide if they're going to defend the case. What we see in these types of situations is before they get to that 60th day, the agency will reopen and they'll send out approval notices to people who are in litigation against them. So it'll take a couple of months to shake out, but typically those cases resolve and they settle out.
Thank you. Thank you for the inputs there. So, John, about the H4 EAD also, now you are saying that the cases are ongoing, right? And you have been able to win. You are saying they're clubbed together, like 60, 70 plaintiffs coming together and doing, not a solo case. Or solo cases are also being filed, people who want to expedite their H4 EAD process, timeline.
Yeah,
you said
we've done solo cases before. It's just, trouble is it's very expensive to put together a lawsuit. It takes a lot of time. And so if you have people that are all challenging the same issue, they kind of can share that cost. So it makes it cheaper for the plaintiffs if they band together in one complaint.
Okay, thank you. Citing the old results, the decision that came for these H4 EAD plaintiffs, would you be doing like similar things, like the side the example you gave the approval for them, now you give the approval for this set of people as well?
So we have a lot of data now from the lawsuits that we've done that shows that there's really no consistency within the agency on how they approve these things. It's completely random if you're going to wait 12 months, 12 and a half months or more, or if you're going to get yours approved within 2 months. There's just no predictability. So part of what we do is we take that data and we crunch it and we look and see what trends are, what the agency is actually not doing right. And we can point to that in court. And a lot of times we do, the agency will try and oppose our complaint, and they'll say, no, our average processing times are this, and this is an average processing time. And we can go back and we can show through the numbers that what they're saying is not true and not correct. So the data is helping us out there.
Thank you. Thank you for those inputs. So if I have to summarize the situation that comes easy for the people who are filing their extensions, amendments, approvals, or anything, what is good now after you have won this case against USCIS? What are the good things that you're carrying?
So overall, what we're seeing in court is the agency's denials based on employer-employee relationship and the specific work and these short-term partial denials. Those things, I don't think the agency has a huge appetite to defend in court any longer. So they tend to settle. They're looking to get away from that as much as they can. What we're also seeing is the denials that are based on the degree requirement. So let's say you're a computer system analyst,
Right.
and the agency denies the petition because the OOH says most of them, but not all of them, have a degree in computer science. The agency has been losing those cases in court, the most versus all distinction. And they tend to settle those cases now as well because they're on shaky legal ground on those denials. If you have a denial, they really should be talking to an attorney about what the options are in terms of going to court and getting it litigated out, or what they should be doing. The odds of success in litigation right now are far higher than an appeal or a motion to reopen with the agency. So it's probably more cost effective overall to litigate your denials than it is to file a motion to reopen or appeal.
Thank you. Thank you for those inputs. And when USCIS is closed till June 4th, how does this procedure of litigation works? A little curiosity is there in mind.
Yeah, so when you file a lawsuit, like I say, you got 60 days for the agency to make a decision if they're going to defend or if they're going to settle the case. We see a lot of movement in those 60 days with cases settling out. So it's going to be tough because what we have to prove in a delay lawsuit is that the government's processing time is unreasonable, that it's, based on all of the factors, it's unreasonable. The whole COVID situation has put a wrinkle in that because if what we've always been used to is different and we're trying to figure out what is reasonable in this new environment. So that's one reason we've temporarily put a hold on new cases that we're filing for the H4 delays until we can kind of figure out how our legal arguments match up against the current realities.
So, yeah, okay, 60 days goes there, and then that's the duration they also borrow. Mm-hmm. That's where they get to stay. Yeah. Right now, because I don't know, people are sitting here and they become out of status as well if massive layoffs happen, and time is coming where we will see that. I don't know whether 2008 would be repeated again, that kind of recession. Although President Trump is trying to save the companies with his PPP plan and everything. What's your take there?
I think it will take the country probably 3 times as long to come out of this as we've been in it. Just because employers are retail employers and everybody are not going to rehire much until they see revenue coming in. So I think we're in for a very rocky rest of the year, probably, is my guess. Whether or not it'll have a huge impact on the IT community, I'm not sure, because even in the recession, the bad times, the IT community or the IT industry still seem to be okay. You know, people still need data security. They still, in order to make money, they've got to have people that are managing data in their computer systems. So I think it's a little bit more resilient towards a recession than other areas, but it'll probably still have an impact as well.
And we are also hearing that President Trump may come back with another executive order, which might be specifically targeted to these non-immigrants, specifically the H-1B community, and they might put a complete pause. Do you have any insights on that? I mean, maybe the new H-1B, lottery that was there, would they stop or something like that?
So they've got a 30-day period where they're going to be evaluating their options when it comes to non-immigrant visas. So not sure what that means and what they're looking to do. I think it would be very difficult from a legal standpoint for the agency to exempt H-2s, the hotel workers, and not exempt H-1s. There's really no legitimate distinction between those visa categories. So I'm inclined to think there's probably not going to be any harm to the H-1B community. The real question is whether or not they'll use this opportunity to push through a change in the regulation on H-4, and whether or not they'll try and change the regulation on the H-4 EAD to take that away. And that's probably one of our next big legal fights is going to be on the H-4 EAD's existence.
Well, there was already a rule, like it was in the process, like with the DHS has proposed assigning the H-4 EADs. And I think that's the next line of action they will take. And regarding that, about the litigation route, as you said, I mean, can there be a class action lawsuit trying to protect? But I believe it's a tough situation now because Americans first, definitely that comes in picture, and they might have to put back H-4 EADs.
Yeah, so the interesting thing is the EAD is relatively new. And when they created the EAD rule for H-4s, they went through what's called the rulemaking process. And the agency published all this information and evidence about why it was a good idea and why it was legally permissible to do this. And all of that data and all that explanation is still there from 2015.
Right.
So if the agency were to change what they're doing drastically, they would have to come up with a principled distinction as to why the legal framework is no longer valid. Nothing's really changed in the law, so I think that's a problem for them. The other problem is there's this legal doctrine it's called the doctrine of reliance. And it says if people have acted in reliance, economically acted in reliance upon a government regulation, then they get grandfathered in going forward. So you see that with like power companies, power plants, right? So if the government were to change a regulation to make it so it's no longer financially feasible to run your power plant, then you would have a reliance interest that you could challenge the regulations applicability to you. I think the H-4s who already have their EAD would have good arguments about that as to why they should be able to maintain EADs going forward into the future and get them renewed, because they've purchased houses in reliance on dual income. They have cars, they have all these expenses. I think if the government does try to kill the H-4 EAD, I'm inclined to think that the worst that could happen is that new ADs wouldn't be issued to people that haven't had them before. Right? I'm inclined to think that people who have them currently would be able to keep them going forward.
I mean, you are saying that people who have EADs will be able to get them renewed, but the people who are about to get H-4 EAD, I mean, the I-140 is getting approved and they apply for fresh H-4 EAD, they might not get it.
Yeah, I think we have very, very strong arguments for why those with EADs now should keep them going forward. And I think that's probably a probable outcome of what will happen in that litigation. It's a much tighter question as to whether or not new EADs will be impacted. I think if the government tries to kill new EADs, that's more likely. I think they have a chance to pull that off in court.
You are creating a lot of positive hopes, Jonathan. Thank you so much for them. I mean, there is always a ray of hope to fight for your rights. Somehow the community is scared and fears getting into any litigation route, and somewhere they feel, I mean, their name might come while filing for green card, even for the individuals who are H-4 EAD holders, or if they get into a litigation route. They also fear, I mean, of course, they're dependents to H-1B, and H-1B people are not going into litigation, but their spouses. But at the end of the day, the green card gets filed through, I mean, this channel where their records would also be shared. And somehow they feel this might impact the primary's green card as well, their green card.
You know what's funny about that is, so the agency hasn't digitized any of the records. Everything the agency does is paper in a folder. And there's a difference between non-immigrant visas like the H-1 and your immigrant visas. When you file a new immigrant visa, they create a new folder with your A number on it, and every document relating to the immigrant visa goes in there and stays in there forever. But your non-immigrant visas don't go in there. The non-immigrant visas, once they're done adjudicating it, they send that paper file archive, which is in a cave in, I think, Arkansas, never to be seen again. And there's no computer system that they can access that will show them what happened in prior visas. So when basically the agency flushes those non-immigrant visas files away. And when you get to the immigrant visa processing stage, none of that is visible to the adjudicator. So I don't think they need to really worry, because on a practical standpoint, none of that's going to be in front of adjudicators making decisions on the green card. I think another practical issue is, my experience was adjudicators are government employees. They don't have an axe to grind. They want to do the minimum amount of work and go home at the end of the day. And if you're going to try and retaliate against people, that actually takes effort. Mm-hmm. And it's not something I see your average adjudicator really getting motivated to do. So my opinion is that there is no retaliation as a general rule, and that most people probably benefit overall from suing the government.
Oh my God. Okay. Thank you. Mm-hmm. I mean, this is a different route, you know, of course, as I said, less taken, but has been successful lately. And especially credit goes to people like you who are fighting for the rights, who are legitimately representing the right things and fighting for them. And we are thankful to you, John, for that, you know, the good work you do. And of course, there are a lot of attorneys, you know, a lot of legal experts in the industry. People like you are very few. And
yeah, we occupy a rare space. You know, there's a lot of very, very excellent petition filing attorneys, but we definitely have a rare niche.
So tell me one thing, if people have to reach out to your office, you know, I mean, the organizations or people who are aspiring to file their H-4 EADs and other things, how do they get in touch with you? I don't do publicity for people, but I want to get them, you know, this is the right information for the right person who's sitting right next here.
So they can go to our website. It's just wasdenbanas.com. Mm-hmm. They can just Google my last name and it should pop up without too much difficulty. My last name and immigration, if they can't remember the website name. And there's a contact tab on the website, or they can shoot us an email. My email is jdwasden@wasdenbanas.com.
So you, you can take up cases from any part of the USA. I mean, your immigration practice does not restrict to a particular state, right?
Yeah, and so I work out of Washington, D.C.,
Mhm.
And because the agency is headquartered in Washington, D.C., everybody can sue in Washington, D.C. to get their petition reviewed by courts. So it makes it easier. If we were limited to
Very
where
important.
the actual petitioner was, it would be very difficult.
I get it. Thank you. Thank you for these insights, John. And, personally, I do advocate for the rights of, high skilled immigrants who are stuck in a green card backlog. And that's where we stand. Maybe I've asked you questions from that perspective as well, because at the end of the day, everybody wants to contribute to this beautiful country by establishing a better connect, by investing more, by having a stable career and thought process of, feeling and having a feeling that this is my own country. Most of the people, their kids are born here. They are in high
Yeah.
school or middle school now. And it becomes next to impossible to wrap up everything in 30 days and go out of this country. I know the future looks dark right now with the coronavirus situation, but yes, your positive lines on saying that IT industry should not suffer a lot, because I believe the future would be remote, and then IT experts would be required to run the business as is, whether it's banking, finance, healthcare, insurance,
Yeah.
retail as well. I mean, people go shop online and all. So all these things are there, but at the end of the day, all statuses should be maintained and they're legitimately presented. There is a lot of opposition, before I close, there are people who feel that H-1B community has misused these visas, and there is extreme misuse of the visas. That's what organizations have opposed, who don't want Indians to get green cards, and they say the wide misuse of visas does not entitle them to get green cards.
Yeah.
Any inputs you get from your circles about this? Because you are an attorney, you file the cases, you know how the case is adjudicated, you are the person who's presenting a case, and I believe you would not do a wrong job there, especially when you come with a background where you were with USCIS yourself.
Yeah, there's a lot of changes that can happen through litigation, and then some things can only be handled through a change in statute or regulation. So, the advocacy on those grounds is very important as well. Most industries have an advocacy branch that advocates for statutory and regulatory change with the government, and a litigation component, so that when the government oversteps their boundaries, they can get sued, and it kind of keeps the government honest. For the longest time, the litigation and immigration wasn't pretty much non-existent. So the government didn't have any incentive to play fair and play by the rules. That's changed under this current administration. I think there's significantly more litigation. So I think hopefully going forward, we'll be able to keep the government a little bit more honest and get them to pay closer attention to what the rules actually are, because we're hoping that eventually they'll get tired of getting sued and they'll come correct.
Yeah, I mean, how many more cases, how many more litigations to set the standards right, where the right adjudication happens for each and every case that goes to the file of the USCIS officer?
I don't know. Probably, I hope to find out the answer to that question one day.
I mean, what kind of class action lawsuit should take place for that?
The class actions in immigration are tough because oftentimes everything turns on the facts of your individual petition. And for a class action to work, all of your details have to be nearly identical. All of your harms need to be the same. So it becomes difficult to do a class action effectively in immigration, I think. So that's why we went with a different model in the IT cert case, which was we did mass litigation instead of class litigation. We flooded the court with a whole bunch of petitions, people that have been harmed, and showed the court a wide spectrum of how bad the agency was doing. And that allowed the court to see the scope of the problem and enter in a decision to kind of address where the agency had gone wrong.
Thank you. Thank you for all the insights, John. And I believe that's where, it's a very, very informative and educational session here. You guided people, and there are a lot of fears versus fact, that you cleared, what is the fact and what is the fear. You should not carry this. And that counts a lot, Thank you for your time today. Any final closing lines on maintaining the right status for this community, especially the non-immigrant workers, the H-1B community?
Yeah, if you have a question about whether or not you're doing something wrong or right with your status, it's worth your time and money to contact your attorney that you trust with your immigration process, because you don't want to ever be in a situation where you step across the lines and do something that's going to cause you harm or problems later on down the road. So just be very cautious, and if you have questions, reach out to your attorney.
Perfect. Thank you. And the last takeaways, to summarize, through your lawsuits that you filed and you won, the takeaways of that people should further take cognizance of them and take action even now the time is available. Can you summarize them?
Yeah, so I think if people have a short-term approval, where within the last 2 years especially, instead of filing a petition extension right now, they really ought to be looking to sue the agency to extend their previously approved petition. Those cases we're doing en masse as well, and we're going to keep doing them until that whole mess gets cleared up. But I think that's the easiest way people can protect themselves right now, is to avoid going through the adjudication process and get those visas extended for a couple of years. Some cases where they've only approved for 1 day, so they could get extended for 3 years. So if anybody has a decision within the last 2 to 3 years where they were denied an H-1B visa because of employer-employee relationship or the availability of work, the specific work requirement, those cases are also really good, especially if it's a cap H-1B and you lost out on your chance for a cap H-1B. You can sue on that and get your cap H-1B back. So those are cases to keep an eye on and go through your records, especially if you're a company owner. Go through those records and see which of those cases that you've got or which of those employees you've got that you can protect and take care of.
Thank you. Thank you for all these insights. I believe time to take action. Time is not lost when the right decisions are there in place now that you've helped them take, Thank you, John, for your time today. And of course, you will have many more people following you and chasing you for the solution, for the right kind of litigation. And we appreciate everything that you're doing for the community and the right steps that you have taken till date. We wish you all the very best. And thanks a lot for your time today.
Thank you. It was good talking to you.
Thank you. And my dear viewers, this was the session with, attorney Jonathan Watson, an excellent person who has devoted his time for the community and has won the cases which are definitely going to help the non-immigrant community even now and in the long run. With this note, we are closing today, and we will come back with another special session where we will keep you informed and educated about your rights. Stay informed, stay safe in this COVID situation, stay home, and stay the best as you can be. God bless. Thank you. Have a wonderful evening. And I'm signing off today now. Thank you so much.